Case number 23-3027, United States of America versus Aaron J. Thorpe, appellant. Mr. Katzoff for the appellant, Mr. Lenners for the appellee, Mr. Rorty, amicus curiae.
Good morning.
Good morning.
My name is Howard Katzoff. I'm representing appellant Aaron Thorpe. This is a criminal case. Mr. Thorpe is appealing the district court's denial of a government motion to dismiss counts pursuant to Rule 48A. The motion was filed in accordance with the court's discussion of Mr. Thorpe's unsuccessful ineffective assistance of counsel claim during his direct appeal regarding the plea proceedings, where a very favorable plea was allowed to lapse. His co-defendant was granted relief. He was denied relief on the Sixth Amendment grounds, but the what's been referred to in the briefs as the Night 2 court cited Renaldi versus United States and stated that the government has the discretion to ameliorate any injustice that would result from permitting the inadequately counseled defendant to accept the original wire plea offer, but not the co-defendant, Mr. Thorpe in this case, whose counsel's performance was adequate. They went on to say, even now, the prosecution may seek dismissal of some or all of the charges against Thorpe under Rule 48A of the Federal Rules of Criminal Procedure. Based largely on that, I believe, the government did file motion to dismiss under Rule 48A. The district court denied that without a hearing. And the issue for this court now is whether the district court erred in denying the government's Rule 48 motion to dismiss.
Mr. Katzoff, what is in the text of Rule 48A that allows the government to seek dismissal after a conviction has become final and the appeals have run out?
Well, it's not so much what's in the text, it's what is not in the text. There's nothing in the text that sets any temporal limit as to when the district court, the executive can exercise their discretion.
The rule is about dismissals. So arguably after a conviction, after a judgment of conviction becomes final, there's nothing to dismiss.
Well,
there's no indictment, information, or complaint to dismiss. There's only a final judgment in the case.
That's correct in terms of that particular language, but the courts have applied the rule to permit dismissals post-conviction, post-sentencing, post-appeal. Although some have questioned it, there's no case that's found that the rule, the text, the history is limiting in any way with regard to that. The use of the term conviction has not been determined by any court to control, or that there's a temporal limit, that it has to be pre-sentence, pre-conviction.
So is it your view that the executive can just dismiss a case at any point? Are there any limits on that? The executive, because they have prosecutorial discretion, can, after a final judgment of the courts, just dismiss a conviction? What's the limiting principle on that? Does Rule 48 do so much?
Rule 48 seems to do exactly that, and it's tempered only by the leave of court requirement, and the leave of court requirement has been universally, unanimously defined as assuring or being a check or balance by the court, that there is some limited discretion that assesses whether the motion is made in bad faith, whether there's improper motive, whether there are the types of factors that were discussed in Renaldi and Watts and other cases, including cases in this court, that suggest that there was some bias, that there is some harassment of a defendant, and particularly where it's been consented, many of the decisions have found that when it's consented, there really can't be any issues of harassment or abuse towards the defendant, which is what Renaldi suggested is the main purpose of Rule 48.
Can you give me the sequence here? The Court of Appeals decides the case and remands the case to the district court, at least for Knight. And then Knight, then the government offers the plea, right, on remand. And Knight accepts it, right? And then it goes to the district court for approval or disapproval. That's the sequence, right? But did the district court approve of the plea by Knight before the district court decided the Rule 48A motion with respect to Thorpe, or were they simultaneous?
The court ultimately took Mr. Knight's plea, and now the procedural history is there's an appeal, ineffective assistance is raised, it's remanded, it's litigated before the district court, and then I assume we're talking about the Knight 2 decision where Knight is granted relief, remanded to the court. Mr. Knight was...
There has to be some further proceedings in the district court with respect to Knight. Number one, the government has to offer him the plea.
Correct.
Right. He has to accept it. And then there's a colloquy that has to go forward under the federal rules of criminal procedure. And what I'm asking you is whether all of that took place before the government filed a Rule 48 motion.
It did. I'm reasonably certain it did. The government perhaps can answer that if I'm wrong.
Well, maybe, I mean, technically it may be critical because, as I understand it, when we're talking about the indictment was against both men in a single indictment, right?
Correct.
And so if the indictment is still open on remand because of the Knight procedure, then it's open. And all this argument about whether, whether there was, because there was finality and this and that and the other thing, I mean, I suppose you can say it was final with respect to Thorpe, but not final with respect to Knight. But if we get into technicalities, the indictment was not final on remand because it was remand.
Correct.
Yeah.
But
so it may make a difference.
Proceedings continued on with regard to Mr. Thorpe, as they often do, as he had time to file his 2255 petition. 2255 petition was filed. That was pending at the time that the...
What were the grounds of the 2255?
The grounds for the 2255 were constitutional violations based on the totality of the circumstances of Mr. Thorpe's inability to accept the wired plea and some ancillary constitutional grounds that were raised, not accepted by the court.
And that was ultimately denied by Judge Leon?
Yes, it was. So those proceedings were ongoing at the time that the government filed the motion to dismiss with regard, and that was a matter before Judge Leon. Judge Leon had a status hearing to address the issues. The case was not closed in that regard. There were proceedings before Judge Leon. Judge Leon set a briefing schedule. Judge Leon decided the matter. And I think within a couple of months after that decision, the government, I think, filed their motion to dismiss. I'm not sure if this is with my rebuttal time or not, but bottom line is motion was filed in good faith, as all the courts have found, to ameliorate an injustice. The evidence of good faith is consistent with the language of the Knight 2 decision, not clearly contrary to the public interest as defined by all of the cases that address public interest. The district court applied its own assessment, putting judicial authority, sentencing authority above the prosecutorial primacy that every court to address it has found. As this court is, or at least some judges on this court have recognized, there's no appellate reported decision of an unopposed or consented to Rule 48 motion being upheld or affirmed. Any.
Mr. Kassoff, you're out of time. Let's see if my colleagues have any further questions.
Thank you.
We'll give you some time on rebuttal.
Good morning, and may it please the court, Dan Lenners for the United States. Judge Randolph, to answer your question, Knight accepted the government's plea offer and was resentenced in 2021, and it was not until 2022 that the government filed a Rule 48A motion.
Okay, thank you.
It's not the government's view that the indictment disappears for all purposes as soon as a conviction becomes final on direct appeal. For example, if a defendant is granted release on habeas, you go back to the trial court and you return to trial proceedings, but the government doesn't have to re-indict the defendant at that time. And so it's not as though the charging instruments disappear from the case. And in the same respect, once a final judgment is entered by the trial court, there's no mention in Rule 48 of dismissal of a conviction or dismissal of a final judgment, but the Supreme Court in Renaldi and Watts and other cases has allowed the government to use Rule 48A to dismiss charges even after the conviction has become final at the trial level.
And even if the remaining portion of the sentence simply violated government policy, not a constitutional violation, not a statutory violation, because in Pettit it was just a policy.
That's correct, Your Honor.
And so here, I take it it's just a policy. I don't know. There's nothing written in the U.S. Attorney's Manual, is there, that covers a situation like this?
There's not, Your Honor. And in fact, this is an unusual case in which something like this would have arisen on direct appeal. This was an ineffective assistance of counsel claim brought on direct appeal, remanded for additional proceedings. But in most courts, most other circuits and most state courts, ineffective assistance of counsel claims are not decided on direct review. They're decided on habeas. And so typically this kind of situation that arose here, which is admittedly rare, and the government's use of Rule 48A, attempted use of Rule 48A after a conviction has become final is very rare, but this wouldn't have even come up on direct review. And so to put a limiting principle on it, Judge Rao, the government doesn't think the court needs to decide that. But if the court does want to address the question, we think that Rule 48A continues to allow the government to dismiss charges at a minimum while a defendant's timely 2255 petition is pending. And the government has some control over the prosecution to oppose that motion or to concede that the defendant is entitled to relief.
What is there in the text of the rule that allows that? I mean, I'm looking at the word dismissal. You can dismiss an indictment, information, or complaint.
I have the same answer as Mr. Katzoff, Your Honor. It's not what's in the rule, it's what's not in the rule. There is no time limitation in the rule. Other rules, such as Rules 33, 34, and 35, have express time limitations. And also, you can't infer from the reference to charging instruments that it only allows dismissal once a conviction has been entered, because that is inconsistent with the Supreme Court's approach in Renaldi.
But so maybe Renaldi we understand as being a statement of how we think about finality, right? Something is not final until all the direct appeals have run out. But once they have, then, the plain text of Rule 48 controls.
So I disagree
I
that.
think Renaldi suggests that the words of Rule 48 have no meaning in terms of what power the government has. And that would be a strange way to read a rule.
I agree, Your Honor, but I also don't think that one can infer that an indictment, information, or complaint continues to exist past entry of final judgment by the trial court, but somehow then disappears when the appeal has become final.
Well, maybe as a matter of first principles, this rule should take hold after final judgment or conviction by the trial court. But we have precedent suggesting that it continues on through direct appeal. But I'm not sure why we should take from that it should go beyond once the direct appeals are final.
And I think the answer to that is there's no time limitation in the rule. And there is a time limitation in the second sentence during trial, which counsels against reading in a different time limitation. And we think that at least to the degree you infer from the use of the word prosecution, that Rule 48 continues to apply while the government has some control over the prosecution, that applies to collateral proceedings such as habeas.
Does that also apply then for 48B? Could a court simply decide to dismiss the charges after at any time? I mean, I guess I'm not sure why there would, why the government could do it, but the court couldn't under 48B.
I don't have Rule 48B in front of me, but I think it contains more express time limitations about when the court is allowed to act that don't exist in Rule 48A. In any event, as we urge, the court doesn't need to decide this issue. The parties didn't raise it below. It wasn't the basis for the district court's ruling.
Well, if there's a 2255 motion pending, it is always open to the government not to oppose it and to confess error. I mean, and I'm sure that has happened. I mean, I can't point to a particular case, but over the years, I think it's pretty clear what happened. Every once in a while, the 2255 raises a question that had eluded the lower courts, and it gets up to the Supreme Court, and the government confesses error. And then what happens? Well, I don't think the government says, well, the indictment's final, and because you were already sentenced, that would make a mockery of 2255. And it doesn't have to accept the government's confession of error. I mean, ever since, I think, the 1800s, when that practice was begun, what the Supreme Court does is just remand the case back to the district court. So it's open.
I agree with that, Your Honor. And that also raises a sort of separate but related point, which is to the degree that there are time bars, the Supreme Court has set forth a structure during which courts may raise them sua sponte. And the courts may not raise them sua sponte when the parties have affirmatively waived any time bar. And clearly here, the government and the defendant, to the degree the court were to read a time limitation under Rule 48, have not just forfeited that argument, but have waived it. The government by moving for relief and the defense by agreeing with the government. And so just like under Rule 33, if the government waives a time bar, the court...
Forfeiture is applied against an appellant or an appellee. Like here, it's the district court that you're saying forfeited. Seems a little odd to apply the same forfeiture rules to a district court that we would apply to a party.
So in terms of forfeiture, we're not arguing that the court has no power to decide the issue. We're suggesting that in the exercise of its discretion, it need not.
An odd exercise of discretion to allow Rule 48 to do what Rule 48 categorically does not allow.
Well, that's what this court did in Smith, and it's what the Fourth Circuit did in Rice. In fact, in Rice, the Fourth Circuit reversed the denial.
Smith, the forfeiture was a forfeiture by the criminal defendant, and that forfeiture was held against him as part of the adversarial process. But again, the district court is not an adversary in an adversarial process.
I agree, Your Honor, but in Rice, the parties forfeited it, and the Fourth Circuit not only found that it wouldn't reach the issue because of
You know of any
forfeiture.
case other than Rice where an appellate court has allowed Rule 48A to, dismiss an indictment after the final appeal has finished?
I'm not aware of any, Your Honor. But waiver is a different issue, and the Supreme Court in Gay versus McDonough said that where the government affirmatively waives the statute of limitations for a habeas petition, it would be an abuse of discretion for the district court to sua sponte invoke it. And then following on in Wood, the Supreme Court said that even though there are times in which a court of appeals might recognize a time bar, they should not do it where there's an affirmative waiver.
Mr. Winters, though, I mean, I'm not sure the question here is really a timeliness one or like a time bar. I mean, in Rule 33, in Smith, I mean, there are specific days. I mean, here, arguably, the question is about the government's authority, about what continuing authority the government has to use Rule 48, in this context where all the direct appeals have run out. I mean, in that prior question of authority, I mean, I'm not sure it's very prudent to think about that as waived or forfeit. I mean, if the government doesn't have the authority to do something,
So I think it's about
I'm not sure the parties can stipulate to the fact that the government does have the authority.
I'm not sure that those are actually different things. I mean, under Rule 33, you could say that the trial court has no authority to grant a new trial, or the government or the defendant has no authority to move for a new trial. But the Supreme Court has nonetheless found that the parties can waive that time bar, and the trial court nonetheless has power to act as jurisdiction. So
Usually with forfeiture and waiver, it's a party that has given something up. Here, it's almost the reverse. The government is asserting a power that Rule 48 may not give it. The defendant is, for understandable reasons, colluding in the government's assertion of a power that Rule 48 may not give it. It just doesn't seem like the forfeiture context waiver applies in a normal way here.
I agree that it's an unusual situation, Your Honor. But I think that, again, this court need not decide the issue. It has discretion, at the very least, to decide whether Rule 48A applies in these situations.
Can I ask, sorry, do you want to finish your
I was
sentence?
just going to say, we think it's commensurate with justice to, allow the government to grant the relief that this court in Night 2 said was.
And you have in fact, you have a statute that authorizes the court to do exactly what you said. And it was cited in Renaldi, although I don't think the parties picked it up. It's 28 USC 2106. And if you take a look at footnote 8 in Renaldi, the court says that what they're doing is giving a just result, and they quote the just, which is from 2106.
That's right, Your Honor. Although I could be wrong, but I think that statute may apply to the relief that the Supreme Court may grant.
No, it says, the beginning of the statute says, the Supreme Court and all other appellate courts. So it applies to us.
And the government thinks that the result that's commensurate with justice would be, in this case, to reverse the district court's denial of the Rule 48 motion as an abuse of discretion. Judge Walker, I don't know if you had a question you wanted to ask.
I did have a couple more. One is just sort of a technical question. Let's say that an appeal is over, conviction's been final for several years, and AUSA discovers Brady evidence that in his good judgment, good faith, thinks requires a new trial. What is the procedural mechanism at that point? And does 48A come into play?
So I think that the Rule 33 provides a 3-year time period for a motion for new trial based on newly discovered evidence. So if you're within the 3 years, I
That
think.
can come from the AUSA or the defendant?
I don't know, Your Honor, but presumably the government would, in that situation, would turn the Brady material over to the defendant, and the defendant would then move. If it were after 3 years, there's certainly possible that the defendant could move under 2255 and the government could waive the 1-year statute of limitations. And if for some reason the government was unwilling to do that, there might be a sort of another exception to the statute of limitations in 2255. But I don't know the answer to that.
Oh, that's helpful. And as I think it through, it may well be the government wouldn't have to do anything procedurally. It would just turn the evidence to the defendant, and then the defendant could make the motion and you'd be off and running from there.
Right.
And I wonder, there's been, and I'm expressing no opinion of whether this is a good thing or a bad thing. But there's been talk in the news that there could be a reconsideration of the January 6th prosecutions if there's a new administration. Let's imagine that that is the case. Would it be appropriate for the U.S. Attorney's Office, under orders from the Attorney General, to file a Rule 48A motion in all closed January 6 cases that are post-appeal and tell the district court you have no discretion whether to dismiss these cases?
Yes, at least under the same circumstances as this case. So where the defendant, even if the conviction is final on direct appeal, which there are very few of those at this point, if the defendant has filed a timely 2255, which is still pending, and thus the government has some power over the continued prosecution, then the executive's view is that it could move under Rule 48A to dismiss those charges, and that the district court would have limited or no discretion to deny them, and any discretion possessed would be based on bad faith.
And what does the habeas 2255 component of this case have to do with whether Rule 48A applies?
The rule refers to the government dismissing the prosecution. And as originally enacted, the Rule 48A said, dismiss an indictment, information, or complaint, and the prosecution shall thereupon cease. So Amicus has argued that that use of the term the prosecution allows the government to move under Rule 48A while it continues to have control of the prosecution, which Amicus's view is through final conviction. But the government retains some control over the prosecution when there's a pending timely habeas petition. As Judge Randolph noted, it can waive time limitations, it can agree to relief.
I'm going to interrupt just for a second.
Habeas relief is not about the prosecution. I mean, the whole point of habeas is post-conviction relief. I'm not sure we think about the government's role in responding to a habeas petition to be part of a prosecution.
But if relief is granted,
I mean, that's not historically how we think about habeas. It's a very strange framework.
well, I point out that if a defendant prevails in a habeas petition, he is viewed as having prevailed in the prosecution for purposes of a Section 1983 claim.
Mm-hmm.
And the government, again, has a substantive role in responding to and can agree that the defendant is entitled to relief. And so that's why we think that Rule 48A...
Prosecutions are criminal matters, right?
Yes.
And habeas is a civil matter, right?
No, I don't think that's right. I think it's the Supreme Court has said it's its own animal, that it's not really criminal, it's not really civil, it's something different.
It's on the civil docket. Right?
It is on the civil docket, yes, Your Honor.
And it's a lawsuit against a warden.
Well, I think they responded to a 2255 motion as the United States. It's not the warden. I could be.
That's a good point. Okay. Okay. And then I wondered how if you're right about Rule 48A, what does that do to the accountability that is inherent in pardons and commutations? So pardon commutation power is pretty absolute, but a check on that, on the president's absolute discretion to pardon and commute, is the president has to put his name on the pardon. And so the public knows if this was a bad decision, they know who to blame. Now, of course, AUSA's answer to the U.S. Attorney, who's answers to the Attorney General, who answers to the President. So you are an agent of the President. But it does seem like if you can do everything a pardon does through Rule 48A post-appeal, you've created a system where a defendant can be pardoned without the president having to sign his name to the pardon?
So I have two answers to that, Your Honor. One is that we don't think Rule 48A entirely overlaps with the pardon power. You can pardon someone who's passed away. We're not arguing that Rule 48A applies then. You can pardon someone before they've been charged. Rule 48A also doesn't apply then. In terms of accountability, we think that the president ultimately acts through the members of the executive branch, and so the president would be accountable whether he or she is personally pardoning the person, or whether the president is acting ultimately through.
There's another difference, and that is Rule 48A requires leave of the court. The pardon and commutation power, despite the General Flynn case, does not require approval.
That's correct, Your Honor. That's another difference.
But your theory is that leave of the court does next to no work, that the court should just always grant a 48A motion that the defendant consents to.
Unless there is bad faith on the part of the government. So if the AUSA was taking a bribe, if the AUSA had animus against the victim, if the AUSA wanted to go on a vacation, the defendant would obviously consent under those circumstances. And although the court doesn't have to address this issue, many courts have said that the leave of court requirement would allow the court to deny it when the prosecutor is effectively acting ultra vires.
Why would Rule 40, if you're right about everything you said and argued regarding Rule 48A, why would it not apply even after a defendant has passed away?
So, I don't even know that. I don't know what's left after a defendant has passed away in terms of a
Their
criminal
reputation.
prosecution.
And I think there's this 1984 case, Korematsu, not the infamous 1940s case Korematsu, but same person. And the government sought to, file a Rule 48A motion. The district court didn't allow it. I'd have to go back and reread whether Mr. Korematsu was still alive at the time. You may remember.
So in that case, Your Honor, Korematsu moved for a writ of coram nobis.
Was he still alive?
He was still alive. He moved for a writ of coram nobis, and the government moved while that case was pending. The government moved under Rule 48A to dismiss all of the charges, and Korematsu opposed that. He wanted a decision on his writ as to, I think, the injustice that had occurred during the Japanese internment, and so the district court denied it. But there was no timely 2255 motion, and Korematsu was not still incarcerated, both of which could provide time limits to the government's power under Rule 48A that aren't implicated by this case.
Mr. Leonard, let me just say, you've suggested that the text of Rule 48A doesn't really matter here. So you're in some sense appealing to general Article 2 power or common law power. But I'm not sure what in Article 2 or the common law would allow the executive to continue a prosecution after the Article 3 courts have said it's a final judgment. Right? So you're not really looking at the text of the rule. So what is your account of, the Article 2 power or the common law power that allows the prosecution to continue in this way?
So I think
or constitutional.
So I think I disagree that we're not looking at the text of the rule.
Well, you said that. There's nothing, in the text that supports what you're saying.
Well, it has no time limit. It says the government may, with leave of court, dismiss an indictment, information, or complaint. And so
we don't have an indictment, information, or complaint still live here.
I agree with that, Your Honor, except to the degree that that's also true on direct appeal. And the Supreme Court has applied the rule then.
Okay, so say through direct appeal, but why after direct appeal?
And again, Your Honor, because the information, indictment, or complaint is still alive to the degree that habeas relief is granted to the defendant. The government need not re-indict.
Okay, but assume I don't buy that argument. Can you point to something in the common law or in the practice of the relationship between the executive and the courts that would allow the executive to do something like this?
I can't, other than to say it appears Rule 48, at least as applied by the Supreme Court, is even broader than the common law. The common law would have cut off when the district court entered judgment. It would have cut off the government's power. And so The Supreme Court has not limited Rule 48A to be commensurate.
They also
with
have not
common law.
expanded it past direct appeal.
That's true, Your Honor.
But you don't have an account of why it should be extended. I'm giving you an opportunity to say why it should be, as a matter of first principles, applied beyond direct appeal. And I'm not hearing an argument for that.
I think I have said why we think that's true, and I would be repeating myself to say it again.
Can you repeat yourself?
Sure. So the rule has no time limit. It says the government may dismiss an indictment, information, or complaint. Those words in and of themselves don't limit it to before a conviction becomes final on direct appeal. And to the degree you think that they must have some limitation, that limitation would continue to apply during habeas proceedings when the defendant could be granted relief and the government would go back and try him again on the same indictment. And when the prosecution continues, in the sense that the government has some control to agree to relief during that time period. And so we think that the rule properly would continue to apply at a minimum while there is a timely 2255 petition.
Can I ask, is there a textual argument you can make under Rule 48A without dealing with Renaldi and all the other cases? And it's this, that in the federal system, you can't have a conviction without an indictment, an information, or a complaint. That's true, right?
Yes, Your Honor.
And if you get rid of the indictment and to say that the conviction still stands, it's sort of like the smile without the cap. And so technically, if you undercut the indictment, the conviction has to fall.
I think that's right, Your Honor. I don't think that the indictment disappears when judgment is entered, or the indictment somehow disappears when the conviction becomes final on appeal, which I think is a different way of saying the same thing, that it continues to exist as a potentially applicable document even after those things happen.
If someone was testifying and they were asked, have you been convicted of a crime? And they said, I'm under indictment. Do you think that would be an honest answer? So assuming that they were convicted of a crime 10 years ago?
It would be an incomplete answer. It would be accurate, but misleading.
I appreciate your rolling with the question, but it does seem really odd to think of someone who was convicted a decade ago as being currently under indictment. It's not how we think of indictments. They end.
I don't think that is accurate to say indictments end. That person was indicted and now stands convicted, but that doesn't mean the indictment has vanished from,
Some of the
case.
briefings cited this really, I thought, thoughtful article in Seton Hall Law Review by Rebecca Krauss. It's called The Theory of Prosecutorial Discretion in Federal Law, Origins and Developments. And it talks about kind of common law, nolle, I'm going to almost certainly mispronounce this, but prosequi.
You're looking to the wrong person, Your Honor.
Does your interpretation of Rule 48A, taking out the with leave of court language, imagine that wasn't in Rule 48A. Does your interpretation of Rule 48A differ from the common law understanding of nolo prosequi?
So I'm going to say nolle. And
Thanks.
yes, because of the Supreme Court's decision in Renaldi. So my understanding of common law use of nolle is that the prosecutor had unfettered discretion to dismiss charges before trial, that it needed the court's consent during trial, and then it once again had unlimited discretion to dismiss between the end of trial, between verdict and sentencing, at which point it cut off. And so that is inconsistent with the Supreme Court's decision in Renaldi and Watts and other courts of appeals decisions that have allowed the government to move under Rule 48A post sentencing and final judgment through the appeals process.
You've been patient with me, and my colleagues have been patient with me. I have one more question. There are B pleas and C pleas, if I'm remembering right. A B plea gives discretion to the district court, although there may be a recommendation of sentencing. and a C plea says to the district court, take this sentence or sentencing range, and if you don't agree with it, then there's not a guilty plea. You would know 1,000 times better than I would. Is that how it works?
Roughly, yes, Your Honor.
Okay. So if you're right about how Rule 48A can apply after sentencing, then it seems like it would eliminate B pleas, really. In effect, it would eliminate B pleas because the government could still do C pleas, they would stay the same. But if the government did a B plea and the district court didn't agree with the recommendation that the defendant and the government have compromised on, and instead sentenced the defendant to a higher sentence, then the government could just, after the sentencing, do Rule 48A every time, just giving the district court basically no discretion. And you would have basically made it so the only way to get a plea bargain is through, in effect, the C plea process.
So I could be wrong, Your Honor, but I think the reason that the C plea needs the court to accept the plea in a way that B doesn't is because it restricts the court's sentencing authority. And so under B, the government is effectively dismissing charges post-sentencing under Rule 48A once the court sentences the defendant. I don't think I'm answering your question, but
I probably didn't ask it well. And let's just take a regular plea, a normal plea, a B plea. The government says, we want you to do a 5-year sentence, and the defendant has pleaded guilty. I think in that situation, the court can do a 5-year sentence or can do a higher sentence, and the guilty plea is still stands, right?
yes, Your Honor.
But if the government doesn't like the sentence, it could then just immediately do a Rule 48A motion and get the indictment dismissed. So it would give the government a veto power over the district court sentencing that it only has now in a C plea context, not in a B plea.
So I guess I have two answers. One is they certainly wouldn't apply in all situations, say to a 1-count indictment or to situations in which the government couldn't just dismiss certain counts to arrive at its preferred sentencing outcome. But more practically speaking, that's not what's at issue here. That arguably could be the kind of bad faith that would allow a court to deny a Rule 48, even an unopposed Rule 48A motion, because the government is attempting to usurp the court's power. But that's not what occurred here. Thank you.
Thank you very much.
Good morning, Your Honor. Opposing counsel. May it please the court, my name is Keenan Rorty, and I'm the court-appointed amicus defending the district court's decision. The district court refused to grant the party's Rule 48A motion because it was deeply troubled by the timing of the motion, and it believed it was not in the public interest. In making that decision, the court did not abuse its discretion. I want to highlight quickly just the 3 things that decide this case. First is that there's no waiver issues. As Judge Walker pointed out, waiver normally applies to parties, not the court. Here, the court was clearly troubled about how the motion was being used. In its own words, quote, to reverse engineer charges on which the government has already obtained convictions and a sentence upheld on appellate review. And it repeated these concerns throughout its analysis. And it held that its discretion was greater than it would be during a pending prosecution. Whether the court was right on that are issues that this court needs to address. Second, the district court did not abuse that discretion. As Your Honor has pointed out, Judge Rao, nothing in the text of the rule allows the government to use the motion in this way. The government and the party seem to say that nothing in the rule stops the government from doing it. But first of all, that's not true because it only allows dismissals of indictments and prosecutions. But second, the government and the parties need to point to something affirmative in the rule that grants that power, not just say that nothing stops it. The parties also say that separate.
What about Renaldi, right? So, I mean, if we were writing on a clean slate, does Rule 48A mean that there's no dismissal after a conviction, after there's a judgment by the district court?
So, and I think some of the statements you were saying earlier are exactly how this court should resolve the case. So I think if we were talking from a clean slate, I think this would be a far easier case. And then the question is, what do we do with Renaldi, since some of this reasoning could seem to apply? I don't think you should expand Renaldi for 4 reasons. One of them is, and this is important, is that Renaldi didn't actually decide whether or not Rule 48A should actually be used in this way. That is one of the insights that this court made in Smith, saying that, okay, it applied Rule 48A, but it didn't explain at all why it did so. And in fact, this court in Smith left open the question whether even in fact Rule 48A applies to convictions. But even if you take Renaldi at face value, you shouldn't expand it, one, because courts have repeatedly noted this discrepancy, and they've always limited Renaldi to the facts that, okay, we're going to keep it pending on, pending appeals, but not
The
further.
theory of Renaldi is in some sense, it's not final. The government says, on habeas, the indictment is still sort of lurking in the background. Could be, if a criminal defendant prevails on habeas, then, we're going back to that indictment. What about that?
And so, and here's why I think even Renaldi is somewhat defensible in a way that trying to apply it here on a 2255 motion is not, because at least here, there's not a final conviction. And at least here, it's a direct continuation of the same criminal proceeding. But by the time you get to a 2255 motion, I mean, it defies the ordinary sense of the word, prosecution, to say that someone who files a 2255 motion is being prosecuted. And, as Judge Walker pointed out as well, a 2255 or a habeas motion is under the civil spectrum as well, or at least some sort of a mix. So, and to go even a little bit further, Your Honor, I think, and the parties appear to have 2 approaches about when the rule can apply. One of them seems to be as long as there's post-conviction remedies, like a 2255. And one of them seems to be as long as, I think someone is in federal prison generally. If the line is 2255, that means that prosecutorial discretion is going to be coming in and out and in and out and in and out, depending on whether or not there's a post-conviction motion. I don't think this court should interpret, prosecutorial discretion as this kind of ghost that comes in and out whenever there's a 2255 motion being filed. And as Judge Randolph pointed out as well, when we're talking about prosecutorial discretion, the Supreme Court has already rejected the idea that just because the government concedes error on a conviction, and in fact agrees that a conviction should be taken away, that means that the district court or the judiciary's hands are tied. No, the Supreme Court has said again and again that a court still independently analyzes whether in fact, this conviction should stand. It shouldn't be any different just because the title of the motion here is Rule 48A rather than 2255. I also want to point out that adopting the party's reasoning about Rule 48A would indeed pose pretty problematic reasons. I don't see very strong limiting principles. As Judge Walker pointed out, I don't really see why, if you say that as long as a Rule 48A motion is filed in good faith, why it couldn't be used, for instance, to pardon all low-level drug offenders if the U.S. attorney, thought that was in the best interest. Or, you can think of any sort of amount of examples. This is a really important point, and it's that the executive does indeed have unilateral authority to remove convictions after the fact. That power exists to the executive, but it belongs to the president alone, and the president is personally accountable for the use of that power. No court, or virtually no court, I think other than the Rice v. Rivera case, has said that prosecutorial discretion just applies, even after a conviction, and especially after appeals.
So Judge Leon got into none of that, right?
So Judge Leon, well, I don't think that's true, actually, in 2 different ways. First of all, he definitely said that here his discretion was much greater than it would be than during a pending prosecution. Now, you're 100% right. I'm adding additional reasons, but as this court has pointed out, it has, quote, no qualms about addressing additional arguments raised by a court-appointed amicus, as long as it's the same essential, issue, I guess.
The question remains, Judge Leon thought that under Rule 48A, he could evaluate the, quote, public interest. Are you supporting that?
Well, so And my key recommendation is that at the bare minimum, the district court did not abuse his discretion in finding that. I think it's honestly arguable that, it would just be an automatic abuse of discretion to use the rule in this way because it does not really apply here.
There's a famous statement by Chief Justice Marshall about discretion. So this is said to be a motion to the court's discretion, but the court's discretion is not its inclination, it's its judgment. And its judgment is guided by sound legal principles. So when you talk about discretion, what are the legal principles that you have in mind?
So, and I think here the legal principles that, and let me know if this is responsive to your Honor's question, is that at least here in the post-appeal context, the court had the ability to independently decide whether granting the motion was in the public interest. And I think he looked at a variety of factors and he reasonably concluded that it was not. Because although it's definitely true that there was one factor that, might support release.
Who better represents the public interest? The United States Attorney or the district judge?
Well, and I think absolutely the government's views should be given weight. And this is actually the Young case, Your Honor, that's cited in my brief. And they pointed out, it's pretty analogous circumstances where the government confessed to error. The court specifically said the public interest is not just entrusted to the executive, it is also entrusted to the courts.
I asked you who better represents it.
Oh, well, and I think that,
It's a rhetorical question.
but I think, and here's the key thing, I think that power is ultimately given to the district court. And so the district court is the one who ultimately needs to make that, consideration. Even though, by the way, I 100%, we 100% agree the government's views and the defendant's views are relevant, absolutely. And, and I'm happy to keep talking as well, but just, one final point is that just to the extent that we're looking at the public interest, as I mentioned, it's definitely one factor, the fact that Mr. Thorpe couldn't take this plea deal, and that was relevant. But there were many other factors that the parties, in fact, said that they did not even have to consider, and they are definitely relevant to any sort of more holistic public interest analysis.
Is Judge Leon's opinion in Thorpe consistent with his acceptance of the plea in Knight?
And are you saying?
If it was in the public interest to require Mr. Thorpe to serve all 24 years of his sentence, why wasn't it in the public interest to require Mr. Knight to serve all 24 years of his?
And I think the key insight is that the scope of his discretion was radically different. Because in Knight 2, they vacated the conviction and remanded to the court. At that point, we have, charging determinations. At that point, the district court's discretion was limited in terms of what he might want to do. But here, there's no charging left. We only have a final conviction. And so, because of basically the vastly different standards of review.
An unconstitutional violation occurred, harmed Mr. Knight, right?
That's right, although it was not his constitutional
And it
violation.
also harmed Mr. Thorpe.
Oh, yes.
Right?
Yes.
I mean, he's suffering from a constitutional violation, and so was Mr. Knight. So why shouldn't they be treated the same?
Well, and hopefully this is responsive, is that I think the district court, let's say he was analyzing, this is now different than the facts, but let's say that the court was analyzing whether or not to accept the plea and he basically had full independent authority, he very well might be, justified in rejecting the plea. But at the plea stage, his discretion is greatly capped. That's not true here. And so I think that, explains the different outcomes.
Okay.
Any further questions?
Thank you, Your Honors.
Thank you. Mr.
I don't know
Katzoff,
if I have any time.
we'll give you 2 minutes on rebuttal.
I guess first I'd like to agree with government counsel regarding the fact that the indictment doesn't die and disappear. A lot of discussion about the nature of habeas proceedings and the fact that the civil rules apply, but they're very much treated with consequences in the criminal case. there's generally a motion to vacate the sentence. If the sentence is vacated,
I mean, just to
then
give one example, a criminal defendant has a right to an attorney, but a habeas petitioner doesn't.
that may be one of the differences, and they are, as said, its own beast. But what I'm saying is that some judges handle them on the criminal docket, some judges handle them on a civil docket. They're not all handled on a civil docket. Civil rules do apply, criminal rules do apply. On 2255s to vacate a sentence, vacate a conviction, if you prevail on that, then the case, if the conviction is vacated, then obviously the indictment is very much alive. So the government continues to have control. It continues to be a live issue. The text inclusion of the word indictment and the lack of any of the temporal limitations in the other rules, as government counsel cited, is part of the basis for having Rule 48 authority past conviction. And it's hard to reconcile Renaldi if you're going to say that there is discretion authority to make a Rule 48A motion post-appeal, post-conviction, post-sentencing, post-appeal, then, and there's still a 22.5, then we're arbitrarily just without Congress's intent, without drafters' intent, without anything specific in the rule, we are arbitrarily setting a limit that doesn't exist anywhere.
Thank you.
Thank you.
I'd just like to briefly talk about Rule 33 and waiver. So Rule 33 allows a defendant to move for a new trial within 3 years after the verdict or finding of guilty. And that could be well after the conviction has become final on direct appeal, which suggests that there still exists some underlying charging instrument under which a defendant could receive a new trial even after the conviction has become final on direct appeal. And the second issue about the related issue about waiver is, as this court recognized in Smith, in finding that a district court has jurisdiction over a Rule 48A motion after a conviction has become final on direct appeal, the defendant could move under Rule 33. The government could waive the time limitation. That doesn't bind the district court on the merits of the motion, but it doesn't allow the district court to deny it as untimely, as the Supreme Court said in McDonough and Wood. And so too here, to the degree that the parties waived any implicit time bar by the government moving the defendant agreeing to that, that doesn't bind the district court's ruling on the merits, but it doesn't allow the district court or this court to sua sponte deny the motion as untimely. Thank you.
Mr. Katzoff and Mr. Rorty, you were appointed by the court to represent, to represent the different parties in these cases, and the court thanks you for your assistance. Case is submitted.
Case number 24-1017, LTD Broadband LLC Petitioner versus Federal Communications Commission and United States of America. Mr. Showalter for the petitioner, Ms. Flood for the respondents. Thank you.
Good morning, Judge Rao, and may it please the court. I'm Michael Showalter, appearing on behalf of LTD Broadband. I've reserved 2 minutes for rebuttal. The FCC designed the RDOF program to encourage innovators and small providers like LTD Broadband to bid for federal support to build out Broadband for rural Americans. The FCC deemed LTD Broadband reasonably capable to participate in the auction, and LTD Broadband was the auction's biggest winner. But after a change in administration, the FCC changed course and applied a heightened and skeptical standard of review to LTD Broadband's long-form application that violates its rules and deprived rural Americans of internet access. The rules say that the Bureau will rely on the bank's willingness to extend a letter of credit and that the professional engineer certification will provide assurance of the applicant's technical qualifications. But the Bureau did not give any weight to those judgments at all. And the Bureau treated the rules as setting a floor and not a ceiling, and imposed new requirements on LTD Broadband that do not appear anywhere in the rules. The FCC has responded primarily in two ways. First, the FCC has attacked aspects of our long-form application, but the merits of our long-form application are not before this court. We believe that we are qualified for RDOF support and that our long-form application should be approved, and that is our position before the agency.
Walter, a sort of uncharitable view of your argument, and you can tell me why it's not fair, would be the FCC is allowed to make sure that the long form application is complete, but it's not allowed to look at the quality of the content that's submitted. And if that's the case, why even have the information submitted if the Bureau is not permitted to review it?
Sure, Judge Walker, that is not our position. Our position is that the Bureau is not allowed to apply a heightened standard of review for companies that are smaller. So it's certainly allowed to review the application, but it's not allowed to apply a heightened skeptical de novo first look. It's supposed to be giving substantial weight to the judgments of...
Suppose there's...
Wait, I'm sorry, the weight of who?
Of subject matter experts, such as the bank and the engineer and the applicant itself with its disclosures and certifications.
Well, no, I'm glad that you asked, and I'm glad that I'm sorry for interrupting you. On the topic of a letter of credit, this is from, and I believe it's, I'm going to confirm right now, it's an unsealed page. It is from the government's brief. It makes this argument, so I'm curious your response. If the letter of credit commitment letter were alone sufficient to demonstrate an applicant's financial qualifications, the other documents that must be filed with the long form application, such as audited financial statements and a detailed project funding description, would be unnecessary.
Yeah, that's a straw man argument. So most of their brief is actually attacking straw men. And our position is that there had to be substantial weight given to the bank's willingness to extend the letter of credit. The words that the rules use is rely on. We think that means substantial weight. If you think about a statutory interpretation case, a dispute, an agency comes to this court and says, we want Skidmore weight. That means this court should rely on our interpretive conclusion. This court would say, no, that's completely wrong. That's not what Skidmore weight means.
What's the FCC supposed to do? Let's say they have a letter of credit commitment, but the audited financial statements suggest that this company is not going to be able to do what it said it would be able to do. What are they supposed to do then?
So I just want to emphasize that the FCC is not arguing that they placed any weight on these judgments of the subject matter experts. If they would have, we would have a different case. So for example, if they had said something like, we recognize that the bank was willing to extend this letter of credit, and we recognize that the professional engineer certified the network design. However, we believe that no reasonable person could conclude X, Y, Z. That would be a different case. But the reality is they've actually disclaimed the need to rely on the bank's willingness to extend the letter of credit because they say that the letter of credit came after the long form stage. The problem for them is that the rules actually refer to the bank's willingness to extend the letter of credit. That comes during the long form stage. And so they've disclaimed a requirement that the rules impose that we think is very clear.
Mr. Showalter, is LTD challenging any of the factual determinations that the FCC made, or suggesting that there wasn't substantial evidence for their determinations?
So our first two questions presented are independent of the substance of our long form application. So
Isn't that strange? I mean, if you're
we're,
not challenging the factual determinations that the FCC has made?
we disagree with the factual determinations, but our position,
You're not arguing here that they're not supported by substantial evidence in the record.
that's not our argument on, so our first two questions presented, one is about the standard of review that the FCC applied, that we think is inconsistent.
I understand those, but you're not arguing that the FCC lacks substantial evidence for its factual findings.
No, Your Honor. So our third and fourth issues presented, we think that the FCC's reasoning was insufficiently explained and it was unreasonable. But the first two questions presented are strictly about the standard the FCC applied and the fact that they failed to provide notice of the requirements that they imposed.
What's this? No, please.
Oh, sorry. I guess I'm not sure I'm not sure I understand this argument that the FCC applied a heightened standard. I mean, they're required not just to determine whether the long form is reasonable, which is the language LTD focus on, but whether it's reasonably capable and whether it's more likely than not, right, that LTD can meet its obligations. So how is that a heightened standard?
So I can tell you, Your Honor, how it's a heightened standard, how they applied a heightened standard, but I would first just say that they have said themselves that they applied a heightened standard. So if you read paragraph 23 of the Commission's order on review, that's the order denying our long form application, they say we're applying additional scrutiny, further inquiry to LTD Broadband's application because of its size. If you compare that with paragraph 76 of the Randolph order, the Commission actually rejected a proposal to apply heightened scrutiny to companies because of their size, using almost the exact same words, further inquiry. They said, we're not going to.
Why don't we just understand that as the FCC trying to determine whether LTD is reasonably capable? And part of the inquiry about whether it's reasonably capable of meeting these obligations is in part related to its size, and whether it's reasonably capable of scaling up to meet these requirements. I mean, the FCC is required to protect the public interest, and before it gives out billions of dollars, presumably it needs to be careful that it's giving it to a vendor that can do what it says it will do.
Absolutely, Your Honor. And we think that the Bureau is entitled to consider company size. It's not our position. We just think that they're not allowed to apply a heightened standard of review based on the company size. That's what they said they wouldn't do in paragraph 76 of the Randolph order. That's what they did ex post. Commissioner Carr's words, they implied an entirely different standard of review that they, quote, made up on the fly. Commissioner Symington said they changed the rules in the middle of the game. And so it's not that they can't account.
So why isn't that just harmless error here? Because you're not questioning any of their, whether there's any substantial evidence for what they found. So if you just took out the words, that you object to in the order, couldn't the FCC just simply reach the same conclusion?
No, Your Honor, we think that if they, under the presumption of regularity, if they reviewed our long form application under the correct standard of review, we think that they would grant our long form application. But the FCC, to the harmless error question, the FCC has not made any sort of harmless error arguments. We think that's waived. If you look at their arguments in their brief, they're arguing that they applied the correct standard of review, that they gave notice because they gave notice after the fact in the iterative process. They're not arguing any sort of harmless error, and we think that's waived. If you look at page 44 of our brief, we address this. It's the national fuel case. That case says if there's alternative holdings, maybe it's harmless error, but if there's mutually reinforcing reasons, that means it's vacatur. And in this case, we have the reasons that the agency gave are mutually reinforcing, and so we think that requires vacatur.
The dissent in the SpaceX decision was awfully powerful. Why do you think you didn't get a dissent in your case?
We can't speculate as to why a particular commissioner voted in a particular way in our case or another case. They didn't write in our case. They did write in the Starlink case. We know what they were thinking from their writing in the Starlink case. And in that case, as I mentioned, they said that the commission changed rules in the middle of the game, applied an entirely new standard made up on the fly. With respect to the Randolph auction, it's the same auction, that issue here, And the standard of review that they applied in that Starlink case, size, scope, and scale review, that's a standard that they introduced with our application and the Starlink application that they've never applied in to any other application that we are aware of, and they certainly haven't pointed to one.
And I certainly agree. I can't expect you to read the minds of FCC commissioners, but I can't think of a reason why, of a likely reason why they would have said what they said in the Starlink case and not said it here unless they thought those bad things were happening in the Starlink case and those bad things were not happening here.
Again, Your Honor, I can't speculate, but the reasons that they gave for dissenting in the Starlink case are based on the standard of review that the commission applied. It's a new standard of review, and they applied a size, scope, and scale review. That's the exact same standard that they applied here. And part of what was going on in those dissents is they're pointing out that the RDOF rules were promulgated under one administration, and then there's a change in administration. Two commissioners dissented in part from the promulgation of the RDOF rules because they were dissatisfied with aspects of those rules. One of them said he was, quote, extremely frustrated about certain defaults in the Connect America auction. And then you have a change in administration. Lo and behold, the two of the three biggest auction winners in the RDOF auction have their long-form applications denied with what these two commissioners called, the two dissenting commissioners in Starlink called an entirely new standard of review.
I have one
But
last.
not in your case.
But it's the same, but again, it's the same standard. So a size, scope, and scale review, that is the standard that they applied to Starlink. That's the new standard they introduced. It's heightened scrutiny, and that's this exact same language that they used in our case as well.
If we were to agree with you on fair notice, what do you think the remedy would be?
The remedy is vacatur, and the agency cannot require what they did not notice. So if you look at the very last sentence of the satellite broadcasting case, the very last sentence of the Trinity broadcasting case, Radio Athens as well, those are very analogous cases. They're cases where an agency denied an application and imposed requirements that were not noticed. And this,
I want you to apply those cases to this case. The remedy here would be you get the money?
No, Your Honor. So the remedy would be vacatur, and they can't impose the requirements that they only noticed ex post. So they can't require us to hire a certain professional engineer. They can't require us to send all these granular details about our customer service center that weren't
You would
noticed.
have the chance to submit the long form application as you argue it should have been required and no more. And then if you submit it, it still seems a little weird. I guess if you completed the version of the long form that you think is best and they find it's complete, but then completeness wouldn't be enough.
Complete is not enough, Your Honor, and we were just talking about notice. So that's the remedy for notice. On the first issue.
I asked it really poorly. Let me try to rephrase. Let's imagine the relief is you get to submit the version of long form that you wanted to submit, and they can't require more than that information. But after you submit that information and only that information, in their best judgment, you're not even close to able to do what you said you were going to be able to build what you said you would be able to build. So in that, do they just give you the money anyway because you've submitted the version of the long form application that you think is the right version?
No, Your Honor. So if you strip out the requirements that they imposed ex post, then they still have to apply the correct standard of review. So if they went back and said, we recognize that the bank said this and the engineer said this, and we recognize we're supposed to rely on that determination will provide assurance of the applicant's qualifications to meet its public interest obligations. And nevertheless, for reasons X, Y, Z, no reasonable person could conclude this. That would be a different case, Your Honor. But that's the sort of analysis that they were required to do and that we would be asking for on remand.
Okay.
Thank you.
May it please the court, Maureen Flood on behalf of the Federal Communications Commission and the United States of America. I'd like to start by saying that the Federal Communications Commission has to be a prudent guardian of the Universal Service Fund, and it was not going to give $1 billion in universal service subsidies to a small company to build, operate, and manage a 10-state broadband network without checking that company's technical and financial qualifications. Prior to the auction, the commission announced that it would require winning bidders like LTD to file long-form applications accompanied by extensive financial and technical data, and then it would perform an in-depth review of that information to determine whether the applicant was reasonably capable of meeting its public interest obligations across the states where it placed winning bids. As the court has articulated in exchange with petitioner's counsel, commission staff reviewed that information and determined that LTD was not technically and financially capable of meeting its public interest obligations. LTD did not demonstrate that it had the financing available to support the network that it needed to build. LTD didn't file sufficient information with the commission. The information it filed did not break down its data by state, even though the long-form application requirements required that level of detail.
I'm concerned about the FCC's argument here that it's not bound by the actions of its staff. That seems to me to be quite remarkable, especially where here the decision was published. And so, I mean, you have a regulation that says if documents are published, then both the private, then parties and the commission may rely on them in those matters. And yet here in your brief before this court, you're making an argument that seems directly at odds with your own regulations. So can you explain that?
Your Honor, we are only making that argument with respect to LTD's position that the denials of other long-form applications for incompleteness meant that the commission could not deny its application on any other grounds.
The commission's argument is that it doesn't have to treat like cases alike if they're decided by staff?
Yes, and that's consistent with this court's longstanding precedent. In the SNR wireless case, which we discuss in our brief, an unhappy long-form applicant came to this court and said that the denial of its long-form application was inconsistent with commission staff's denial of other long-form applications. And because commission staff granted those other applications, the commission had to grant its application. And this court, relying on longstanding precedent, the Comcast case, for example, said no. In fact, actions by the commission staff never bind the commission. It doesn't establish a policy that the commission has to file. And again, this court, that's what this court held in a nearly analogous case. Again, I point out here, the commission was not disavowing the findings of its staff with respect to LTD's qualifications for universal service support. In fact, the commission adopted those findings in the order on review. We are only relying on the SNR wireless precedent to object to LTD's argument that the staff's denial of long-form applications on incompleteness grounds somehow means that the commission is prohibited from denying long-form applications on grounds other than completeness. It's also inconsistent, Your Honor, with the language in the auction procedures public notice and the commission's auction rules. The commission repeatedly stated that long-form applicants would have to file extensive information with their long-form applications and that the staff would perform an in-depth review of that application to determine whether they are qualified. There would be no point in requiring long-form applicants to file that information with the commission if the staff was not going to review it. Now, I want to speak to the letter of credit issue because I think this is very important. The petitioner is asserting that the commission had to defer to the bank's willingness to issue a letter of credit to establish that the applicant was financially qualified to meet its public interest obligations. That is not correct. That is contradicted by paragraph 64 of the auction procedures public notice. The commission very clearly stated that its staff would evaluate the information filed with the long form application and rely on a bank's willingness to issue a letter of credit to determine whether or not the applicant was reasonably capable of meeting its public interest obligations. So it was a two-part requirement. The staff evaluated the information filed with the long form application. The letter of credit is one element of that, of the body of information filed, and it would rely on the letter of credit or the willingness of the bank to issue a letter of credit. I'd also like to point out that a letter of credit doesn't establish that a long form applicant is financially qualified. A letter of credit covers at most 2 years of universal service support
Ms. Flood,
payments.
have you ever applied the scope, scale, and size review that you applied here, aside from the Starlink case?
Sure, there is no scope, scale, and size review. The commission applies the same standard in its review of every long form application. Paragraph 76 of the auction procedures public notice directed the commission staff to evaluate whether a long form applicant could scale up its operations to provide a broadband network in the area covered by its winning bid. So what that means is, as the commission was evaluating whether a long form applicant was qualified for support, it considered scope, scale, and size in reviewing every application. If you're looking at how an applicant is going to scale up, you have to look at where the applicant is today and where it has to go. So even in applications from companies as large as Comcast or Charter Communications, the commission staff looked at scope, scale, and size. Here, what happened was the commission staff looked at the information that LTD filed with its long form application and reasonably determined that LTD had failed to demonstrate that it could scale up. And that
If they were a bigger, let's say they were the biggest company, the biggest, whatever the competitors are, let's say they were the biggest of them.
Sure.
Would you reach the same result?
No, not necessarily. Again, what happened was the commission applies the same standard. Are you reasonably capable of meeting your public interest obligations? So if a large company came in and it wanted to expand massively, but it didn't have its financing in order, the commission staff could theoretically find that it's not financially qualified for universal service support. It really depended on the showing made by the applicant. And again, this scope, scale, and size review is a fiction.
The number of households that they were supposed to eventually build out to, that I think it's in the public record, the number.
Originally, Your Honor, it was more than 500,000, but through defaults, at the time we denied the long form application, it was, I believe, 367,000 residences and businesses in 10 states.
What's happened to them?
Sure. So as a result of their default, they were denied, obviously, universal service support. What that means is the areas covered by LTD's winning bids are now eligible for universal service support. Now, I shouldn't say that's a misnomer, not universal service support. We do universal service support, but they are eligible for broadband funding from other state and federal programs. So the states and the federal government, NTIA with the Department of Commerce, the FCC, state commissions, state authorities, have all sort of decided that they are not going to provide duplicate support for areas that lack broadband. So when the commission said—
But we don't know these 300,000 or 500,000. We don't know whether Department of Agriculture or some other organization, some other government entity has provided them service.
No, Your Honor. And to be honest, I think a lot of those other state and federal programs are waiting to see the outcome of this case, because you could imagine that if they granted broadband funding to one of the areas covered by LTD's winning bids and the court ruled against the commission, which you shouldn't, you should affirm the order. But then
They might
you
just
would
wait
have—
until Starlink provides them the service without the government's help.
Pardon me, sir? What about Starlink?
Those other agencies might just wait long enough for Starlink to provide them the service without the government's help.
I can't answer that question.
I think if I were one of these 300,000 or 500,000, I would not be thrilled with what the FCC has done here. Like Congress appropriated, or not, but there is money, there's government money to be spent to provide any service. FCC picked LTD, and then FCC made a decision that means these people will have to wait probably years longer to get service unless Starlink gets it to them first.
Well, no, Your Honor, let me point out a few things. Number one, the FCC did not give them this money. They won the money in the auction.
No,
Commission-
the people. No, I'm talking about the household,
Okay.
not LTD.
That's not necessarily true. I mean, let me start by saying the commission reasonably decided to take a conservative approach here. We're talking about universal service dollars.
My only point is, whether you call it a conservative approach or not, it seems like an approach that was at the expense of those 500,000 households who don't have internet and were hoping to get internet sooner.
No, you're not, Your Honor, and here's why. This is a 10-year program, okay? What that means is in the first 2 to 4 years of the program, the winning bidders don't actually have to build out facilities to serve those customers. It's most likely that many of those customers wouldn't start getting broadband service for at least 2 years, okay? The commission decided that if it denied the long form application now, those areas would be eligible for funding sooner. The other thing too is that the commission.
Can I ask, why does it take
Sure.
10 years?
Because
I mean, I don't think it's going to take Starlink 10 years to get all these people covered.
Your Honor, many of these companies aren't Starlink. Many of the winning bidders in the auction, including LTD, were going to use fiber technology.
I mean, Starlink without the FCC's free money.
Your Honor, the Starlink issue isn't before the court. LTD is before the court, and LTD was going to use fiber technology. But let me point this out. You know, if the commission took a chance, if we took a chance with LTD, right? LTD's build-out milestones wouldn't come into play for 2 to 4 years. If LTD was not, in fact, financially and technically qualified, they might default 4 years down the road. At that point, the commission would be pulling universal service subsidies back, but those customers would be stranded. So if you're talking about delay, Your Honor, the commission did take a conservative approach because it was the commission's judgment that rather than taking a risk on a company that might default 4 or 5 years down the line, it would not grant the application, and it would free those areas up so that they could basically be eligible for universal, I keep saying universal service, but broadband support from other programs, and potentially that support would be taken by companies that were actually qualified to serve those areas. You know, the commission isn't required to give $1 billion to a company on the hope that it will be technically and financially qualified to provide the services that it's committed to provide, right? Again, it took a more conservative approach here. You know, and I wanted to point out, the record shows that LTD was not financially and technically qualified for universal service support. And I would also point out that LTD has never asserted that the commission's findings in that regard are not supported by substantial evidence.
Why didn't the FCC make a harmless error argument here?
Honestly, we were not sure about the standard of review that the petitioners were asserting that we should apply if we got it wrong. In other words, to this day, the commission isn't entirely clear about whether, if the court finds that we were in error, we are simply supposed to approve the application because they filed a network diagram certified by a professional engineer and demonstrated that a bank was willing to issue a letter of credit. If we're allowed to review the application for completeness, not sure if that means that we're checking that they have a document titled project funding description, or if we're actually allowed to look at the substance of the application. And because we didn't know what the standard of review was, it was hard for us to make a harmless error argument, right? Because if we're not allowed to look at the application, then it brings to question whether or not we were actually even allowed to look at the substance of the application. I hope that answers the court's question. I would say this, you know, when we grant a petition for review, we don't usually direct the agency what action it has to take on remand. I mean, we would vacate the denial, but we wouldn't direct the FCC to grant the application. Well, respectfully, Your Honor, the question before the court is, did we apply the wrong standard of review in LTD's case? So to remand, you would have to find that we applied the wrong standard, and presumably in doing so, you would clarify the standard that we would have to apply if you remanded in reviewing LTD's long form application. That was our thinking on the matter. I will say that, under even the most deferential standard of review, LTD is not technically and financially qualified for universal service support, and the commission's findings in that regard are reasonable. And I would also underscore again that LTD has never asserted that those findings are not supported by substantial evidence.
I have one little question. It doesn't go to the merits or anything else. I'm just curious. You referred to a petition for review, and I looked at the caption that the FCC and the LTD filed, and it says respondents and et cetera. This is an appeal, isn't it?
No, Your Honor, it's a petition for review because the commission.
Now, the statute, the jurisdictional statute calls this an appeal.
Your Honor, I don't have the statute in front of me, but
I
we.
Which is why I'm asking the question.
Sure, no, I understand.
Okay.
We viewed this as a petition for review because typically with 402B cases, which are appeals, we are denying a license. Here we weren't actually denying a license. We were denying an application for federal money. And so in that sense, we viewed it as falling under section 402A. We didn't identify a category under 402B that LTD's.
Okay, that was the appeal, right? B?
Appeal is B.
Okay.
Petition for review
So
is
A
A.
goes back to the Hobbs Act?
Correct.
Okay. And the
Can I
Hobbs
answer-
Act, and the
go ahead.
Hobbs Act is petition? I don't think so. I think it says pursuant to the statute, but
Your
our
Honor.
clerk's office will get this straightened out.
Sure. I mean, Your Honor, we were responding to what the petitioners filed. Now, that said, we have an independent obligation to make
Petitioners
sure that they're.
said it's appeal from the decision of the FCC.
Your Honor, I apologize that we might have messed up. I don't have the statute in front of me, but if the clerk's office does clarify our error, if we made one, then we appreciate that.
Okay.
Thank you. Thank you, Your Honors. I would ask the court to deny the appellant's appeal or the petitioner's petition for review, whichever it might be. And I thank you for your time.
I'm going to try to just quickly tick through a couple of things. First, I think my opposing counsel conceded that the FCC has not made any harmless error argument here. On the standard of review, again, I just asked the panel to compare the language of paragraph 23 of the Commission's order on review denying our long form application with the language of paragraph 76 of the RDOF order, using almost the exact same language, and the Commission did exactly what it said it wouldn't do ex ante. On rely on, it's a conjunctive, so we had a dispute about this in the briefing, but even if you accept their view on the evaluate and rely on, it's still a conjunctive, and so they still had to rely on the bank's willingness to extend the letter of credit. That did not happen here. On the need to prevent waste of government funds, there's no safe options, so there is the risk that an applicant will not fulfill its public interest obligations. But on the other side, there's the risk that people are not going to get, rural Americans will not get broadband internet, as you pointed out, Judge Walker. And so the Commission was trying to get these funds out quickly. Chairman Pai said we want to get these funds out as quickly as possible. And so it's balancing multiple risks. On one side, the risk of public interest obligations not being fulfilled, risk on the other side that the funds won't get out quickly to deploy broadband to rural Americans. And then lastly, I would just say, since they focus so much on the size of our company, we think that at minimum, they should have granted us partial authorization to service some of the states that we bid and won for.
But you did not ask for.
That's true. Well, actually, Your Honor, so they knew the whole time that we were seeking partial authorization because, as you pointed out, we had withdrawn our bids in 4 states that we had won. So we were, the entire time throughout this iterative process, we were seeking authorization for some, but not all of the states that we had won.
I have one kind of 10,000-foot question.
Mhm.
Some of the precedents deal with a government agency that's regulating entities that just want to be left alone. And, you know, we require the agency to satisfy certain procedural requirements, notice requirements, et cetera. But that's not your situation. Your situation is you want free money from the government. And in that situation, you know, is there something to be said for kind of like you live by the capriciousness of this agency, you die by the capriciousness of this agency?
I don't think that's right under this court's case law, Your Honor. So there's no natural right to these funds, but there's no natural right to the licenses that the applicants were seeking in Trinity Broadcasting, Radio Athens, Satellite Broadcasting. And we are entitled to have agency action that follows the rules and procedures that are promulgated ex ante.
I agree.
Okay, thank you.
Thank you.
This is submitted.
Case number 23-5280, United States of America versus Facebook Inc. Appellant. Mr. Ro Honda for the appellant, Mr. Cowan for the appellate.
Take 3 minutes for rebuttal.
Good morning, James Rohonda. May it please the court. James Rohonda for the appellant, Meta, formerly known as Facebook. The core issue to be decided on this appeal is whether the stipulated order imposed the injunctive relief in the FTC administrative order. That was the linchpin of the district court's decision. He disagreed, but the record is overwhelming on that point. The parties in the district court repeatedly said that what was happening was the stipulated order was imposing that injunctive relief. There's a companion question, which is whether the FTC has the power under the statute to do what it is doing. Does Section B permit modification or enforcement of the administrative order? So let me just start with the reasons why the stipulated order imposed that injunctive relief. The first is the consent motion. If you look at the circumstances surrounding the entry of the stipulated order, the consent motion was absolutely clear. It said, here's what it said. This is at A89 of the record. It said the stipulated order requires Facebook to pay a $5 billion civil penalty and imposes significant injunctive relief, primarily in the form of an amended administrative order that would be entered by the FTC. In other words, the district court is imposing the relief that's contained in that administrative order. Meta said this, and of course that consent motion was made on behalf of the government with the consent of Meta, but Meta also put in a number of briefs in connection with approval of the consent decree.
It seems to me there are a couple premises that you're not stating. Number one is that the FTC has no enforcement authority. It has to go to a court to get its orders enforced. That's number one. Number two, the FCC or the FTC has no power to issue an injunction. Number three is only the district court can issue injunctions. And so those premises then, when you apply that to statements like this, indicate that if the significant injunctions are contained in the administrative order, it has to be injunctions issued by the district court.
Yes, Your Honor. In fact, the FTC, as Your Honor stated, has no injunctive powers. And in fact, what's going on here is not simply that the FTC is usurping the district court's jurisdiction. It's in effect usurping the court's injunctive powers. It's basically saying, we came to the court, we got an injunction, and now we're saying, thank you very much, court, thank you very much, Meta. We'll take it from here and we will issue new injunctions. That is not, statute does not permit that whatsoever. So I would agree with Your Honor, exactly those premises are exactly true. The error that occurred here was, and I think the ramifications of that, as Your Honor said, is that's the premise. So you have to look for some authority, other authority that gave the FTC the ability to do what it's doing, modify. And if you look at Section 5B, that's the only statute.
If the 2020 FTC order had not been entered pursuant to a court order, then the FTC would have the authority to modify it. Do you
Well,
agree
Your
with
Honor,
that?
it only,
If there was just an ordinary FTC order,
right,
not-
yes.
yeah, administrative order, they would have the ability to.
Well, it would have to be an administrative order, and there's a clear distinction. They went to federal court as instead of what they did in 2012, they proceeded by administrative complaint. So if it were an administrative complaint and they met all the requirements of 5B, then they could modify it. But if it's an administrative complaint means there's a notice of hearing. If you read the statute 5B, it has absolutely no application
I
here.
understand that. So even though, say I agree with you that the FTC has no modification authority over the 2020 order because it was entered pursuant, by a district court. Why is Facebook's remedy not a petition for review in this, right? That the FTC is impermissibly exercising its modification power.
Because I think an injunction is appropriate in the situation where the government is proceeding in an improper forum and it was required to go back to the district court and to sort of, because the district court retained jurisdiction. The other piece of this is the record is absolutely clear that the court imposed the relief in the administrative order, and it's equally clear that the court retained jurisdiction. So there was no other option for the FTC to do anything other than come back to the federal court if it wished to modify or enforce the order. And
I don't think that's what the district court said in its order approving the stipulated order. And I read this on my iPad, and I'm now for the first time trying to read it in the appendix. And unfortunately, the important part of the district court's opinion is not in the appendix. It runs, I don't know whether my colleagues saw this, but it runs from A196 to A227 with a gap. But do you have your appendix in front of you, Counsel?
I don't have it. Do you want to see this?
Yeah, it's page 200. Thank you. Just want to point out.
I believe the relevant portions on A201 or concludes.
Well, yeah, the court said that the order doesn't prevent the FTC, and I'm quoting, from bringing new enforcement actions, right? If it learns of additional violations, right? So if that statement is true, and I've looked through the order and the attachment, and I don't see anything that contradicts it, then this seems to me almost a tempest in a teapot, because the FTC could have framed up this revised attachment order as just a new complaint, couldn't they?
No, well, that's not what it did. It didn't bring a separate complaint.
But that's all it had to do, is
Well,
just put that in there and then ask the district court to enforce it.
I don't think in that passage, the court is talking about additional violations in the sense of what has been alleged here in what's put forward in the order to show cause.
Well-
Additional violations would be violations that hadn't occurred to date. When you're talking about enforcing or modify, the court at 201 addressed specifically the issue. In the context of retention of jurisdiction, the court said The court ends by noting that under the stipulated order, it retains jurisdiction over this matter, including to enforce its terms. And then it goes on to say, in the event the parties return to this court, because
Can I finish the sentence?
my apologies.
You have it in front of you. It's the top of 200. It's the second sentence. As the United States explains, this is the district court, the stipulated order does not stop the FTC from bringing new enforcement actions against Facebook should it learn of additional violations of Section 5 of the Act, even if those violations occurred before July 12th, 2019. So if it learns of violations that it didn't know about before July 12th, and it learns of other additional violations, it can bring a new action. And so I get back to the question, I mean, if the FTC can do that, then what are we arguing about?
Well, it can't do what it did here. It can't, that's not the same thing as what it's doing here. What it's doing here is bringing an order to show cause with respect to the stipulated order and an administrative aid.
The FTC, in Judge Randolph's hypothetical, have to have a different burden of proof than to make a modification to
Yes.
the old order? I mean, wouldn't that be
Well, that,
a much bigger burden on the FTC?
it would be, and it'd be
entirely new
quite different.
complaint?
And I think it's very clear in context, that's talking about additional violations. If there's a new thing that the FTC discovers, it could file a new complaint. Nobody's contesting that. But at 201, the court says, what happens if Facebook violates the terms of the amended administrative order? And it says this in the context of retention of jurisdiction. It says, in the event the parties return to this court because the United States alleges once again that Facebook has reneged on its promises and continued to violate the law or the terms of the amended administrative order, the court may not apply quite the same deference to the terms of a proposed resolution, then cites this court's Microsoft decision. So what it is saying is absolutely crystal clear. The court is saying, if what you're alleging, not new violations, but what you're alleging are violations of the terms of the administrative order, my retention of jurisdiction, I'm retaining jurisdiction over that. That's what the court said at the time it entered the stipulated order. This is the memorandum opinion filed on the docket right before the stipulated order. And the parties agreed. The parties stated this. In fact, the FTC continued to state it after the stipulated order. If you look at the course of performance, this is at A611, I believe. The FTC wrote to Meta and said, it's the stipulated order that's imposing the critical provisions of the amended administrative order.
Ask my earlier question maybe a different way. So here, Facebook is challenging the FTC's order to show cause, right? So that's a particular order that the FTC has issued. Does it matter to Facebook whether they seek review of that order here in a petition for review or whether they have review, under stipulated order in the district court?
Yes, absolutely.
Okay.
It matters greatly. I mean, the standard of proof is different. The review is different. The review is different. I mean, the factual findings that the commission would make, it's an entirely different process. And in fact, Your Honor's just dealt with a case. That's a completely different process than what should happen here, which is if they wanted to enforce or modify, which is what they specifically said they're doing, we're enforcing and we're modifying, they have to go, it's a judgment. This is a judgment. They have to come back to the district court and satisfy 60B for that. If they want to go off and file new allegations and new complaints, they could do that.
That's the alternative, is it? I mean, at least my impression from your argument is that instead of filing a new attachment, a modified attachment A or whatever, they should have filed in the district court to hold Facebook in contempt.
Well, they could have tried that. They could have tried to do
That is
that.
the usual, in structural injunctions, one of two things happens when there's a violation. And by structural, I mean prisons and schools and antitrust. One of two things happens when there's a violation. You either go back to the district court and try to tighten up the terms of the injunction, or you hold the party in contempt.
They had multiple options. They could have sought modification under 60B. They could have sought contempt. They could have sought civil penalties under 45L for a violation. They didn't do any of those things. The path that they chose, interestingly, is the path that would expand their powers under 5B. And that path it's crystal clear they don't have the power to do that. That's the 5B allows them to modify administrative orders that are issued on a notice of hearing with a stipulated record or litigated record. And it's actually, if you look at 2.32C, that's a federal regulation that deals with settlements of administrative complaints. So that doesn't apply here either. But it's very clear from 2.32C, that says if you're in the settlement context of an administrative complaint, you're in the settlement context, not fully litigated, then the respondent has to agree that the order that results will have the same effect as if it were litigated, and you have to agree to modify. And so it's treated in the same manner as a litigated or stipulated record. So that actually what's interesting, the import of 2.32C is it demonstrates that 45B does not, or 5B does not cover settlements like this. So,
Mr. Arnott, I mean, should we give any deference to the district court's own interpretation of its stipulated order?
no, Your Honor,
Why is that?
because this is a contract. The consent decree is a contract. It should be interpreted according to the intent of the parties and the circumstances. Gordon Pickford said, circumstances surrounding the entry. You can look at the course of performance. And the court did not address, for example, the conclusion of the memorandum opinion. The evidence of what the parties intended is absolutely overwhelming here. There's nothing cited by the other side. They're over here. There's nothing cited by them that suggests, no, that the parties did agree that it could be modified, or that the parties thought that the administrative order was not being imposed, the terms were not being imposed. There's nothing on the other side of the ledger. All of the circumstances and the evidence as to what happened here comes to at least one conclusion, which is the stipulated order ordered the relief contained in the administrative order and it retained jurisdiction over that. And that meant they had to come back to the district court in order to enforce it.
The FTC vote to put it on the FTC docket was 3-2. If the attachment A was kind of part of the district court's order over which it would retain jurisdiction, I don't understand why the two dissenters would have voted against putting it on the FTC docket.
I don't think it was intentional, but I think it was left unclear. That argument made by the FTC was sort of unclear. The 3-2 vote occurred back in July of 2019, because that's when they were authorizing the settlement. The court didn't approve. It's not like the court approved this in April 2020 and then the FTC considered it. The FTC already had voted to approve the settlement that was then submitted to the court in July of 2019. And then the court took action in April 2020, having considered the consent decree. So all that happened after the entry by the court of the stipulated order, all that happened was a few days passed. It was a ministerial act. They just put the document that was attached to the stipulated order on file at the FTC. And it's very clear why they did that. It says it in the consent motion.
Right. And you're saying there were no dissents from that ministerial action?
No, there was no dissent from that. And it was done to replace the 2012 order. And very interestingly, the 2012 order, which was an administrative order, had a modification provision. The 2020 did not, and that has to be viewed again as intentional. Thank you.
Thank you.
Good morning, Your Honors. May it please the court. Zach Cowan for the government. Your Honors, pursuant to Section 5B of the Federal Trade Commission Act, The FTC is conducting administrative proceedings designed to protect the public. Specifically, it is trying to determine whether it should modify an administrative order with respect to Meta's data privacy based on allegations that it is now, for the third time, misrepresented its data privacy practices to consumers.
Mr. Cowan, how does the FTC retain modification authority when there has been a consent decree and the stipulated order? I mean, here the stipulated order says the district court retains jurisdiction. It makes it clear that it's granting the injunctive relief that the FTC sought, through the administrative order, that is Appendix A. And so that's all part of the settlement that the government came to with Facebook. How does the FTC continue to have modification authority in that context where an Article 3 court has entered a consent decree and stipulated order?
Your Honor, I want to start by clarifying exactly what the settlement required here. Now, the government has a lot of cases where they seek a stipulated order involving the Federal Trade Commission. And often in those cases, part of the injunctive relief is laid out in the stipulated order with some of the same sort of obligations that you might see in what's attachment A to the stipulated order here. The parties here are very sophisticated. They spent months working on this, and the precise term that they used was not that the court shall order all of these obligation terms. Rather, the party said that Meta shall consent to modification in the administrative proceeding. And there are reasons, Your Honor.
To read it that way, so when they consent to modifications, they're also consenting to the FTC continuing to modify into the future? So like they've come to an agreement where they pay a large fine and they agree to all of these onerous terms in Appendix A, and the FTC gets to continually unilaterally modify those terms? I mean, why would a private party agree to that?
Your Honor, pursuant to Section 5B of the FTC Act, the FTC has the authority to make a modification where there are changes in fact or law or the public interests are required.
After it's received $5 billion from the respondent?
Your Honor,
I have the same qualm that Judge Rao has. The bargain was, we'll give you $5 billion and we'll accept these terms for injunctions, right? And you say we can change the terms for injunctive relief. So are you going to give the $5 billion back because they don't have the benefit of that bargain any longer?
So, Your Honor, I think there's essentially two questions. And I think the first is, why would they have agreed to the $5 billion settlement? And I think the second question is related but slightly different. Why would Meta have agreed to have the FTC issue that order, knowing that the FTC has the power to modify under Section 5B? So I want to start with the $5 billion and then hit the second point as well.
You might want to also mention along the way why the court in the attachment means the FCC or FTC.
Yes, Your Honor, and I'll certainly address that as well. So starting with the $5 billion point, it's important to recognize that when settling the case, there are a lot of claims that the government should have sought even more money related to this case. Ultimately, the final relief sought was essentially $5 per violation. The statutory cap for those penalties is over $40,000 per violation. So there was a serious risk of overhead that Meta could have ended up paying a lot more money if it actually litigated this case to resolution. So that's
Settlements are all about. Yeah, go on.
Exactly, Your Honor. So I think that's one reason to explain why it would have settled the particular allegations at hand. I think there's a separate question of why the commission and Meta would have agreed to issue the administrative order as a part of, issue the conduct relief as a part of an administrative order as opposed to a court order. And I think this makes sense for several reasons. Under Rule 60B, as this court is well aware, there's cases such as Salazar that makes very clear that relief under those circumstances is very stringent. It's very difficult to modify without finding sufficient reasons to do so under Rule 60B. However, actually having a modification of the FTC's proceeding, the Supreme Court has recognized, for example, in International Union, their Elmo cases, the Elmo cases are both other examples. The commission can modify based on changes of fact, law, or the public interest. That could also benefit Meta to actually have that flexibility. And we actually see that in parts 2 and 3 of the administrative order that was ultimately entered.
What about the fact that the FTC's order says that it will be in place for 20 years and the district court discusses that? Doesn't that also suggest some limitation on the FTC's modification power?
I think it recognizes that the order would be in place absent some additional action, Your Honor. And I don't think Meta is necessarily, Your Honor, I think the same is often true for stipulated orders as well. They'll contain some provision, but that doesn't bar the stipulated order from then considering new conduct related.
Did the FTC have to enter Appendix A, or is the FTC's position that even after the stipulated order, they could have, modified Appendix A when they were making their 2020 order?
As Section 2 of the stipulated order is laid out, Meta only agreed to provide its consent to waive its rights with respect to the particular modification that would have issued at Attachment A. Could the commission have done something different? Perhaps, but if it did, Meta had not agreed to waive any rights with respect to that. I think realistically, Your Honor.
I think it's possible the FTC could have, after a court entered an order, the FTC could have put in place something other than Appendix A, and it would just be to Facebook to challenge that?
Well, Your Honor, so Judge Kelly.
That FTC has the authority to do that?
As Judge Kelly correctly recognized, he never imposed the obligations that were listed in Attachment A. So if the court would have been, if the commission would have imposed different obligations, it would in no way have conflicted with the court order. I think that's important to understand. But to the extent that the commission decided to go
You
seek.
can make that argument with a straight face. I mean, if a party consents to certain terms, they're only consenting to somehow put it into, the FTC register. That's all they're consenting. They're not actually consenting to the terms. I mean, that's the argument that the government wants to make here.
Well, so Your Honor, to be clear, Meta consented to certain terms. And the parties are very sophisticated. They very intentionally didn't bind the commission to do anything. There were several points in the briefing below, at the time the order was entered, where the parties recognized that the commission retained its discretion. It continually invoked the commission's discretion to modify its own administrative
They're
order.
so sophisticated, then why did they contradict your argument by inserting into the Attachment A the following sentence? This court retains jurisdiction over this matter.
So, Your Honor, I think it's important to recognize this court retains jurisdiction is the first finding. And as Judge Kelly recognized below.
Don't leave out the of this matter.
That's
And
right.
the matter is what the court is retaining jurisdiction over in a document that's the Attachment A.
Absolutely, Your Honor. So this court has jurisdiction over the matter. And the question is, who made that finding? And if you look at the sentence that immediately precedes this court has jurisdiction, it says the commission makes the following findings and issues the following order. That second sentence cannot be read without the sentence that immediately precedes that. And it's also worth noting that even though it is Attachment A, immediately at the top of the heading is United.
Yeah, I know what the heading says. I also know what the FTC said in filing their motion for the district court to accept it. And as counsel for Facebook, I pointed out, the opening line of that motion on page A89 says that this stipulated order requires Facebook or imposes significant injunctive relief, primarily in form of an amended administrative order. A question I'll ask you. Does the FTC have any authority to impose injunctive relief?
Your Honor, Judge Kelly looked at the statements.
No. Yes or no?
Does it have, I beg your pardon?
Does the FTC have any authority to impose injunctive relief?
It has the authority to issue an administrative cease and desist.
Does it have authority to impose injunctive relief? The answer is no. It doesn't. It has to go to court. And so when you see a representation by the FTC that the stipulated order imposes significant injunctive relief, which then explains that it has to be talking about the court.
But Your Honor, the second half of that sentence goes on to say primarily in the form of an order that will be issued by the FTC.
Primarily, right.
But if Your Honor, if I'm following you correctly, if the FTC never has authority to issue an injunction, the FTC could not issue an order imposing injunctive relief either, as that sentence goes on to suggest.
Unless it did it as part of a settlement and a consent decree. And that's exactly what happened here.
Respectfully, Your Honor, Section 2 of the stipulated order as written is very clear that the FTC would be issuing an order pursuant to Section 3.17 of its rules.
So the FTC puts in this order, but you've admitted, the FTC lacks enforcement authority. So what it seems to me is happening here is the FTC is using its modification authority in order to basically bring an enforcement action. And I think it's worth looking at. The FTC's proposed order here makes very substantial revisions to the 2020 order and imposes many new obligations on Facebook.
Absolutely, Your Honor. And the proposed modification.
And so to do that, though, you can't do that through a modification. You're trying to enforce the 2020 order by changing it and, with modifications. But I don't see where the FTC has that authority under the FTC Act.
So I want to respond to the authority point. And before I do so, if you don't mind, Your Honor, in terms of the actual scope of the changes, I just want to point out that those aren't currently before the court. The Meta will have an opportunity to contest those under Section 5C.
But they give a sense of the flavor, right? For instance, like Part 10 says Facebook, before Facebook can introduce a new or modified product or service, its most recently privacy assessment must show that its privacy program meets the requirements of the order. And that is a very substantial restriction on a private company, that it can't introduce a new or modified product or service without the approval of the agency. And perhaps that's something that the FTC could impose if it brought a new complaint and a new order. But to put those types of terms into, this innocuous sounding administrative modifications authority, it seems like you're bootstrapping the fact that, you have no enforcement authority into the modifications authority.
Well, Your Honor, so just taking the statutory point. So of course, as I indicated, it would be, Meta could seek review of that under Section 5C, and that's what Congress intended, was for them to file, as Your Honor mentioned earlier, a petition for review after the commission reaches a final decision on what modifications are appropriate. That question isn't before the court today. The commission is still trying to determine whether any modifications are appropriate at all. And so we're not at that point today. But what I would say, Your Honor, just in terms of the pure statutory question, Section 5B does authorize the commission to modify an administrative order, quote, in whole or in part, based on changes of law, fact, or the public interest. Again, those questions were raised below.
That just goes back to Judge Randolph's question, which is that this isn't an ordinary administrative order. It's an FTC order that was, with a variety of forms of injunctive relief imposed pursuant to a court order.
Well, Your Honor, we would respectfully disagree that it was imposed pursuant to a court order. I understand that the language Meta is relying on, but Judge Kelly said that's a retroactive characterization of what actually occurred.
So I have a question. Would it be different if instead of putting the terms of the order into Appendix A, those terms were, just listed in Judge Kelly's order? Would that actually be different?
Absolutely, Your Honor. And in most cases in my personal experience working on these cases, typically the terms are included in the stipulated order. This is a unique setup that the parties did here, where they said shall consent to modification of the administrative proceeding.
If in fact they had been, to follow up on Judge Rao's hypothetical, that if in fact all these terms have been put right into the order itself, the FTC still would have the authority to modify. But the difference is they couldn't do it on their own. They'd have to go to the court and ask for a modification of the terms of the injunctive relief, right? And so the FTC has that option, and there are Supreme Court cases, there are cases all over, in the courts of appeals and the district courts. One that comes to mind is Rufo in the Supreme Court, where they go back and they keep modifying and modifying consent decrees. So that could be done. And in fact, if in fact the attachment A is, this is not a question, I guess it's going to soliloquy, but if attachment A is part of the consent decree, then the mistake the FTC made was doing it on its own without going back to the court.
Well, Your Honor, so typically Rule 60B applies for court modifications. Right. And for reasons I've mentioned, the parties had an interest in making sure that the FTC could continue to modify its own administrative order pursuant to Section 5B. as the Supreme Court has also recognized, the FTC's authority to modify a final commission order is much greater than its authority to the court's authority under Rule 60B and traditional principles of res judicata. So there's a lot more flexibility for both parties, the commission and Meta, to actually issue this order through a cease and desist order or injunctive relief or whatever other term, though it's not traditionally injunctive relief as the court would issue. I did want to also clarify one point. Judge Walker asked earlier whether any commissioners dissented when the modification was actually issued in 2019. At A380 at the bottom of the page, it does very specifically say that 2 of the commissioners did dissent. And the commission, when it issued the order at A380, it did make an independent statutory finding that a modification was in the public interest. If it truly believed its hands were tied and it was unable to modify its own order, it could have simply noted the court's judicial resolution of the matter. It would be no reason for it to make its own finding. There would be no reason for the commissioners to dissent, and Meta could have objected to the finding, but that didn't happen. Even when the modification occurred, as contemplated by the parties, there was an independent finding by the commission that a modification was appropriate. Judge Kelly recognized the same thing, and he again said that this shows that the FTC retained its discretion and believed it retained its discretion to modify its own order.
Do you think that if we were to agree with the FTC here, would it ever be possible for the FTC to enter into a private settlement? I mean, if the view is that a private party can settle, have a court order, and recognizing the settlement, but then the FTC can just continue indefinitely to modify its orders. I mean, I assume no private party would ever agree to settle.
Well, Your Honor, typically, in most cases, the FTC always, when it does issue administrative orders, it still has the statutory power that Congress gave it under Section 5B. There are some circumstances, such as Elmo, where the commission and the party have reached some sort of agreement to limit that power in some way. And the parties could do that potentially with the commission if they wanted to do so. But by default, Congress determined that the FTC should have authority to modify its own orders to protect the public.
Isn't that default overridden by the fact that we have a court order here?
No, Your Honor, I don't believe so, because the court order, again, it's very important to recognize how the parties set up the settlement. It says, shall consent to waiver of its rights and to modification of the order. The Meta was never ordered to actually modify its order in any way. And Your Honor, that's
it's modification of the decision and order with the decision and order set forth in attachment A. So they've agreed to attachment A. They've not just agreed to like any modification, right? I mean, to the modification, to the decision and order set forth in attachment A.
Absolutely, Your Honor, that's right. So, and that brings me back to what I said a few moments ago about, first of all, it's ordering defendant to consent. It doesn't order the FTC to do anything whatsoever or the United States to do anything. And that decision was very intentional by the parties to use that language. But additionally, it says waiver of its rights consistent with the modification that we discussed. Perhaps the FTC may have tried some other modification and Meta could have, argued against that. It could have retained all of its procedural rights. Realistically, that's not what happened here.
Can you explain what's going on in the United States motion and the FTC's motion, the joint motion, to accept the settlement agreement on page A93?
A93, yes, Your Honor. Is there a particular line to which you're pointing?
At the top. The injunctive relief provisions articulate specific but flexible compliance terms designed to ensure that Facebook and its controlled companies protect user data. And then these are listed. They're injunctive relief terms.
Absolutely, Your Honor. So here's what I'll say. The procedure that was used, at times the injunctive relief, the FTC's cease and desist order was called injunctive relief. And there's a lot of discussions. The procedural mechanisms here are pretty complicated, but there are other things I want to point out in the record too that essentially make this distinguishing point where the government, where it felt like the government and neither of the parties expressly every single time they discussed the procedural mechanism that was occurring, re-articulated the entire process every single time. But I would point the court to A155, for example, where the parties specifically say there are two separate orders that would operate together that would let the DOJ obtain discovery rights. If the court's order gave full discovery rights, there would be no reason for you would have to rely on both orders together for the DOJ to get discovery rights. That seems to imply that the FTC's order and the court stipulated order had to operate in tandem to give the government that right. So, of course, Your Honor, there are places where it's referred to as, for example, as injunctive relief. And you could say, well, the commission doesn't issue an injunction. But there are other places in the same briefing record where the parties took much more care to distinguish the two types of orders that were at play. And ultimately, for those reasons, Judge Kelly said this was a retroactive characterization of the record.
There's language I think there's language in attachment A that talks about the FTC having the right to appeal.
That's right, Your Honor. I mean, the full sentence together, and again, this was selectively exerted in some of the briefs, but it says both Meta and the commission appeal the right to challenge or otherwise contest the validity of the order. That broad language is essentially trying to scope out any type of challenge. So whether it be a challenge to the validity of the order in this proceeding or in some other proceeding, the administrative proceeding, whether by the commission, by Meta, whoever else, really that long provision is just to say the order is, essentially cannot be appealed at this time.
Let's say that the FTC actually acted illegally when it modified what it modified. What do you think is Facebook's recourse?
Do you mean, so the FTC hasn't modified.
Okay, so let's say after the show cause order, they decide they're going to modify the order on their docket, the entry on their docket, the 2020 order, 2020 FTC. Let's say they modify that.
Sure.
And Facebook thinks that that's illegal. Imagine Facebook's correct. What should Facebook do then?
I think pursuant to Section 5C, they would file a petition for review with this court.
And what would our standard of review be?
I think it would be deferential. I don't have the exact statutory language in front of me, but I believe it's deferential, some sort of deference under 5B and 5C.
If the district court does have continuing jurisdiction over compliance with attachment A, then do you concede that an injunction would be appropriate?
If this falls within the court, if it falls within the district, if the terms were substantively ordered by the district court, then the district court would have jurisdiction, but the district court didn't substantively order the terms.
And if it has jurisdiction, then an injunction by the district court would be appropriate.
The one reason I hesitate on that, Your Honor, is Meta has recognized at page 15 of its reply brief that the commission retains authority to modify the order in some circumstances. And those circumstances are laid out in parts 2 and parts 3 of the stipulated order. It creates an unusual situation where essentially Meta is claiming that the commission can modify the court stipulated order in some circumstances, but that seems inconsistent with the idea that it would be the court's administrative order at all. I mean, the court stipulated order at all. So it's a strange situation to even encounter.
It sounds like a yes.
Well, but Your Honor, if it were the court's order, why would it authorize the commission to modify parts 2 and 3, the stipulated order? It seems like the court would have given it power to do that.
I mean, that may be part of a good argument that it's not part of the court's order and the court did not retain jurisdiction. My hypothetical is, imagine we disagree with you and we find that the court did retain jurisdiction. I think at that point, an injunction would be appropriate.
I think there are similar cases where the court is enjoined under those circumstances, yes.
What page of the reply brief you from?
Reply brief at page 15.
Is there a particular sentence you have in mind?
Yes, Your Honor. One second. It says the existence of two orders does not detract in any way from the district court's imposition of injunctive relief as part of a consent decree over which it retained jurisdiction. It goes on to discuss bilateral, what it characterizes as bilateral modification.
Possible bilateral modification of certain injunctive provisions without further court approval, as consent decrees routinely do.
Your Honor, I'm not aware of any authority that the parties can work together to modify a court's order absent the actual court making a decision to do so.
I'm not either. Thanks.
Thank you. For these reasons, we would ask that you affirm the district court and deny Meta's motion to enjoin.
Thank you. I wanted to clarify my response to Judge Walker, your question. The written dissents were written in 2019, and that was a 3-2 vote, and those were the written dissents. When the deal came up after the judge approved it, of course, they reissued they stated that they had dissented. There was no new opinion. Nothing occurred in those 3 or 4 days between the time that the court entered the order and the FTC.
I don't want to eat up your time, so I'll let you do a minute 30, but I don't think that's right. I want to ask you about that.
Okay. The point here is it was ministerial. The deal was locked and loaded, and the claims had already been released pursuant to the order. The question about whether it makes a difference if in the body of this, whether the attachment A was in the body of the stipulated order or not. I mean, it was filed on this in the same filing on the same docket. It's contract law that it would be incorporated into the stipulated order. And in any event, there needed to be something to be able to be filed on the FTC docket so as to replace the 2012 order. The parties said that in the consent motion. As to this court has jurisdiction, I don't think the government can continue to take the position that the commission is a court. It's not a court. Congress creates courts. Congress knows how to create a court. If they truly had support for that, they would cite us to the act of Congress that created the FTC as a court, and it's never referred to itself as a court. The interpretations provided by the government really make no sense. It makes no commercial sense that Meta would agree to pay $5 billion, enter into an injunction that could be freely modifiable by the FTC, imposing new injunctive relief, which in any event would they're not permitted to do. Only courts can do that. In terms of the question about harm to the FTC, I agree with the point that it would harm the FTC. Parties would not agree to settle if their counterparty could freely rewrite an injunction over time. And as to 5B, it's just critical that the language in 5B, we continue to hear the position that that 5B allows modification of the FTC's orders. That's just not correct. It says that it can modify orders under this section. So you have to look at the order that's being contemplated under that section. It's an order that results from a complaint issued on a notice of hearing where there are factual findings made and a cease and desist order is issued. That's not what we're dealing with. And there is no other, in addition to no statutory authority, there's no agreement to modify. The fact that the parties may agree that Meta could seek from the commission certain modifications, that is of no moment here. Of course, a consent decree can allow all sorts of things that it was up to the court to approve that or not, and the court approved an order that allowed Meta to seek in certain limited circumstances modifications to that order.
So on JA 380, this is the order modifying the prior decision. Says it's ordered the matter will be reopened. It's further ordered that the 2012 order will be modified with the attached decision and order. And right after that, it says by the commission, commissioners Chopra and Slaughter dissenting in the present tense, not they dissented a long time ago when the original settlement was being bargained for. So it seems to me like two commissioners dissented from this 2020 modification.
Yes, the two commissioners dissented.
Okay. And if they dissented from it, that suggests that if they dissented from the modification order, that suggests the modification order was not ministerial confirmation of a locked and loaded deal.
Well, the you need a majority vote, and the majority of vote had already taken place to approve and go to the court with an agreed upon deal with two dissenters.
Right.
So
In one world, there's the FTC's vision of how things played out, which is the court issued an order that was binding, and Facebook agreed not to object to the entry of attachment A on the FTC's docket. And that was the extent of the deal. It didn't tie entering attachment A by itself did not tie anyone's hands other than Facebook could not object to the entry of it in the FTC. And in that world, it makes sense that if two commissioners didn't like attachment A, they would dissent from entering it onto the FTC's docket. But in your world, it was a locked and loaded deal, and entry of it on the FTC's docket was simply ministerial. And in that world, it really doesn't make any sense that two commissioners would dissent from a ministerial act that confirms a deal that was already locked and loaded.
well, I think they were preserving, I think the fairest reading of that is if they hadn't dissented, then they might have been waiving the prior dissent with that they had issued, saying, we don't agree, you should go to the court with this deal. And so the reason I say it's locked and loaded is there already was a release in the stipulated order signed by the court. Essentially
Yeah, but
resolved.
under your theory, those two commissioners voted to defy the district court. It's an odd thing for commissioners to vote to do.
I don't think, if that's a fair reading of it, it could be that they're preserving, they weren't so much defying it as they were saying, we've not agreed to this in the first instance. We understand it's going forward, and we are dissenting from this again. But it really doesn't change the fact that the deal had essentially been done. I suppose if the hypothetical is additional commissioners had said, well, we're going to dissent from entry of this order on the docket, Meta would already have had its release in place and the claims would have been released. So it really, when I say it's ministerial, I think there's the court, it wouldn't undo the federal court's order. If you're saying that only Meta had to agree and the FTC didn't agree, the claims would be released.
Okay.
Thank you.
Okay, thank you.
The Honorable Court is now adjourned until Thursday, November 2nd at 9:30 a.m.